So we are now being recorded, and we're also streaming this on Facebook Live as well. So today is the third of our webinar series around the COVID-19 pandemic. And we, as the Chamber, we have put these series together for our members and businesses so you can have a chance to hear from and ask questions from the experts that we have in our membership network. And this morning we have three great lawyers joining us from McLennan Ross. And so we have set time aside at the end for any questions you guys may have. There is a Q&A box that you can type your questions into, and we'll go through those at the end. Or if you prefer, you can use the raise your hand feature, and I will then unmute you and you can ask your question that way. Sometimes it's easier to ask than it is to type the question. So I'll be watching for any raised hands as well. And we do ask if you do have like specific questions that might be related, that might have information that you don't want shared with everybody or on Facebook Live. Those questions can be taken offline. I will share the slide deck to everybody as well afterwards. And Corbin, Richard, and Graham's contact information will be in there. So you can, if you've got any specific questions, you can send those to them. If you haven't already, you can check out the McLennan Ross website. They have a really great COVID-19 resource page, and I do encourage you to check it out. They've got stuff in there from construction all the way to your employees and how you should handle that. So they've got lots of resources there. And we're going to get started here right away. But first, I'd like to introduce you to our lawyers. We do have Graham Henderson, and Graham is a senior associate focusing on construction litigation, insurance and risk management, and commercial disputes. He has extensive experience advising clients in a wide range of litigation matters, including builders' lien claims, contractual disputes, debt collection, defamation claims, and personal injury claims. Graham also regularly advises government and industry clients with respect to bylaw interpretation and enforcement. Next, we have Richard Wong, not to be confused with the president of the Chamber, Richard Wong. This Richard Wong maintains a diverse commercial litigation practice with a focus on construction disputes. He has experience at assisting individuals and corporations on various construction matters with respect to contractual disputes and builders' liens, and has appeared before the provincial court and the Court of Queen's Bench in Alberta in representing clients on these matters. He has also resolved disputes through mediation, arbitration, and other forms of dispute resolution. And then we also have Corbin Devlin, who represents construction owners, general contractors, trade contractors, suppliers, and design professionals in a manner of all lawsuits, arbitrations, negotiations. His litigation experience includes commercial disputes, but particularly tendering disputes, construction defect and delay claims, breach of contract disputes, negligence actions, and builders and miners lien matters. He's also experienced in drafting and negotiating all major construction contracts. So now I'd like to open the floor to our lawyers. Gentlemen, there you go.
Thank you for the introduction, Kendra. Good morning, everyone. This is Richard Wong here. I'm a resident of Spruce Grove, but work at McLennan Ross in Edmonton, which is a full-service firm located just at the west side of the downtown core, next to the Brewery District. The firm itself is a medium-sized firm that was founded over 100 years ago, with our main office in Edmonton and offices also in Calgary and Yellowknife. And by full service, I mean that we practice in almost all areas of the law, including corporate, commercial, and securities, labor and employment, and of course, construction law. So in light of the ongoing changes in legislation surrounding the COVID-19 pandemic and the information in the media, which I appreciate is overwhelming at times, we wanted to provide an update and summary on some of the background numbers and circumstances affecting you, the requirements in place to try and mitigate the spread of the virus, and how this has affected business, and in particular in the construction industry and related services. More specifically, we'll be discussing various contract-related issues connected to COVID-19, the potential claims that you may have or that you might be exposed to, and some tips on how to continue the viability of your business during this time especially in light of the court restrictions and temporary changes to legislation. This slide is just an update on some of the numbers as of yesterday, and we see that there are over 2,000 reported cases in Alberta and just over 30,000 reported in Canada. Yesterday, we had 162 new cases, which is a little bit up from the previous days, with the majority of these cases occurring in the Calgary zone, with just over 1,000 and about 400 in Edmonton. There have been 85,000 tests in Alberta as of yesterday, and Alberta has one of the highest testing rates in the world, so that might be the reason why we're seeing these increase in numbers, especially because testing is now available to any person exhibiting symptoms of COVID-19, including cough, fever, shortness of breath, runny nose, or sore throat. But prior to determining if you need a test, you should complete the self-assessment on the Province of Alberta website. And unfortunately, we've had 50 deaths in Alberta as of yesterday and over 1,000 in Canada. At this point, it's expected that we might need 2,250 hospital beds out of the 8,500 that we have in Alberta to deal with this COVID-19 crisis, with the peak of cases projected to be around the middle of May. And so we've been dealing with this formally for about a month now. And although schools and childcare centers are generally closed, some select licensed childcare centers have reopened to provide childcare for core service workers. This includes frontline health workers, critical infrastructure workers, first responders, military personnel, and anyone who works in essential services, which includes those in the construction industry, and I'll explain a little bit more about this in a bit. Luckily, in Spruce Grove, there are 2 childcare centers open and 1 in Stony Plain. There are also restrictions on care centers, which are pretty strict, where visitors are prohibited altogether unless the resident is dying and a family member, or in rare circumstances where that resident's care needs cannot be met without that visitor's assistance. I think we've also gotten used to the Tri-Leisure Center and other recreational facilities being closed, but golf courses have also been added to the list of prohibited recreational facilities, so we won't be at the links in Spruce or the Stony Plain Golf Course anytime soon. Although workers at the golf courses are permitted to maintain the courses as long as they follow the public health measures that prevent the risk of transmitting COVID-19. So once this is all over, I'm sure those courses will be in great condition, as they always are. And if you're concerned that someone isn't following a public health order, you can remind that person by not doing so it's against the law and puts other people at risk. Or you can also submit an online complaint to an Alberta Health Services public health inspector through the Province of Alberta website. And as we know, Alberta has restricted gatherings to protect Albertans' health and limit the spread of COVID-19. And it's a little different than some of the other provinces. Alberta's defined gathering as any event or assembling that brings people together in person, in a single room or single space, indoors or outdoors, at the same time. And at this time, gathering restrictions do not apply to any place of business still permitted to operate. There are no gatherings of more than 15 people in any indoor or outdoor location, and people gathered in groups of fewer than 15 must maintain that distance of 2 meters from one another. Albertans are also prohibited from accessing personal service, cosmetic enhancement services, and wellness studios. So personal and cosmetic enhancement services include manicures, pedicures, piercings, tattoos, artificial and spray tanning, hairstyling, and barbering. And right now, I think it's too late for you to go and buy your own clippers if you're brave enough to cut your own hair. And all individuals within a business, including the owners, workers, volunteers, and patrons found to be in violation of a public health order are subject to a $1,000 penalty. So that's important for business owners to know. And the same goes for those attending or gathering with more than 15 people. Courts can also administer fines for up to $100,000 for a first offense and up to $500,000 for any subsequent offense for these more serious violations. And again, if you're concerned that someone isn't following the public health order, you can submit a claim online, or complaint online, sorry. But at this time, it's uncertain what further restrictions may come depending on the compliance of Alberta residents. So over the Easter weekend, for example, the Chief Public Health Officer of the Northwest Territories issued 2 new public health orders. And one of the orders, which I want to be clear applies to the Northwest Territories, not Alberta, prohibits indoor social gatherings by individuals altogether who do not live in the same household. Outdoor social gatherings are also restricted to 10 people, and those where there are less than 10 people they're required to maintain that 2-meter distance from one another. So these restrictions are clearly more strict than Alberta, and hopefully it won't be necessary if we're able to comply with the restrictions currently in place. Moving on to the construction side of things, the impact of COVID-19 and whether or not your projects are permitted to continue is primarily dealt with at the provincial level of government and is being dealt with differently by different provinces. To a lesser extent, decisions made by the federal and municipal levels of government are also having an effect on projects. In Ontario, for example, all but large construction can continue, and in Quebec, only essential construction can continue, whereas as of March 30th, construction projects in Alberta can continue nonetheless. Although this may change as labor unions in Ontario, BC, Alberta, Quebec, or other provinces call for site shutdowns. And as I mentioned, the province has deemed construction and various construction-related groups as essential services. Examples of this include construction projects and services associated with the healthcare sector, including new facilities, expansions, renovations, and conversion of spaces that could be repurposed for health space. Construction projects and services required to ensure safe and reliable operations of critical provincial and municipal infrastructure, including transit, transportation, energy, and justice sectors beyond the day-to-day maintenance. Construction work and services, including demolition services in the industrial, commercial, institutional, and residential sectors. And construction work and services that support health and safety, environmental rehabilitation projects, among many others. But the important one is the catch-all, which includes, as the slide reads, any other construction project that can safely abide by the Chief Medical Officer of Health's public health guidelines or directives. This is a very broad group, which I think we're fortunate to have at this time, which unlike some of the other provinces, do not see the construction industry, services, or workers, including you and our clients, as essential. And I think Corbin's going to be more specific on how this affects our business.
Thank you, Richard. I'm going to dive into a bit of a discussion now more focused on construction contracts. And starting with, I guess, what we're seeing in the contracts landscape right now, there's been progression from initial urgency and I guess even in some cases panic about a month ago to a bit of an acceptance now of the changed situation, but the situation, as Richard says, is still changing. It's still evolving, both on the legislative side and also on the contractual side. And with that comes uncertainty, and probably the primary piece of uncertainty is how long will this all go on. And so in the construction sector, our clients are seeing disruptions in terms of manpower, in terms of disruption of the supply chain, changed site conditions and workflows as sites are dealing with the requirements of the public health authorities. And in many cases, there's the possibility of shutdown, whether it might be mandatory, as has occurred in some provinces, or voluntary shutdown for protective reasons, as we've seen in some cases, some of our clients electing to shut down or suspend construction work. Next slide. So those considerations all have schedule and cost impacts, and in some cases can even go to the extent of putting project viability in jeopardy. Whether it goes to that extent or not, we have significant cost and schedule impacts to many parties in the pyramid of construction contracts that make up the industry. And from that, of course, we have the prospect of various civil claims to navigate and mitigate. And that's a primary piece of the equation when our clients are consulting with us. The first thing that we see, that we've seen already, is some payment disputes that have arisen out of interruptions in cash flow and uncertainty about the future of the of projects and of the industry generally. The bigger piece that is yet to come is delay claims, as we see many projects being impacted in terms of productivity or in terms of other schedule impacts, such as temporary suspension of activities or manpower shortages, supply shortages, and whatnot. There can be other breaches of contract that arise. Shutting down a worksite voluntarily can be, in some circumstances, a breach of contract. And we'll talk a bit more about that later. We've had to navigate that risk on behalf of some clients already. Next slide, please. So with our clients, I guess we're dealing first with the question of assessment and response to the risks that we've got in this current situation that were certainly unforeseen at many levels. And I should emphasize that this discussion is looking at the contracts piece. There's other pieces, such as the human resources and employment aspects that are outside the scope of our discussion today, but that are certainly key considerations in all of this. But when it comes to the construction contracts piece of it, we see that the challenges are similar industry-wide, but the circumstances vary greatly from sector to sector and project to project. And likewise, the contract provisions vary. And so the responses and our advice tends to be quite varied and case dependent. And so the questions that we're being asked, if we have to shut down a project pursuant to a government order, or maybe due to an outbreak among the workers on our site, or if we choose to shut down for protective voluntary reasons, are we protected or are we liable? Or if a trade or a supplier gets delayed or otherwise impacted and maybe cannot or will not continue with the project, are they on the hook? Are we on the hook? Who's on the hook for the loss that's going to result? And the bigger complication, as I've already mentioned, is we don't necessarily know if this is going to be short-term, medium-term, or long-term in terms of the impacts of the project. And so it's an ongoing assessment. Next slide, please. The first question that we are addressing, I guess, in terms of the contractual situation for most clients is an assessment of whether there's a force majeure clause in their contracts and how does it operate and is it triggered. So I'm going to spend a few minutes here discussing what is force majeure and how does it apply. Force majeure is a concept that gets little attention in the normal course, but it's getting huge attention over the last month in the circumstances of this pandemic. A force majeure clause is common in certain construction contracts and many other contracts in other sectors as well. And it normally frees the parties from liability or obligation when an extraordinary event or circumstance beyond either party's control prevents one or all parties from fulfilling their contract. It's critical to note that it's contractual. The triggering event must clearly fall within the scope of the force majeure clause in the contract itself. There is no force majeure concept that exists if it's not set out in the contract itself. The application of a force majeure clause also requires that the triggering event is beyond the control of the parties to the contract. Sometimes that's expressly stated in the clause itself, but even if it's not, that's the way these clauses are interpreted by the court. So it can't be something that one or another party can control. The COVID-19 pandemic is certainly going to trigger some force majeure clauses. However, in many cases, it will not. A case-by-case assessment is going to be required. So I've got a few examples to illustrate the point, I suppose. This first one on this slide here is a fairly generic standard form of force majeure clause, and a relatively simple one because some of these clauses can be a page long. This one is very brief. You'll see that this force majeure clause specifically lists the triggering events, act of God such as earthquake, hurricane, tornado, etc. You'll notice that it doesn't mention pandemic or epidemic, or maybe something like order of the health authority. And that's in fact very common. There are force majeure clauses that make specific reference to pandemic, but we've found that they're pretty rare. Now, with respect to this particular force majeure clause, it's debatable, but it's not likely that the pandemic is covered by this clause because it's not listed, and these clauses tend to be interpreted quite narrowly by the courts. Now, that said, this situation is going to see some new case law arising in relation to force majeure clauses in the context of a pandemic. And we're likely to see some evolution of the law over the coming months. Next slide, please. This next example of a force majeure clause is taken from the CCD-C2 form of contract. So this is about as close as you get to a standard document or a standard force majeure clause, in this case, in the construction industry. And this one is a bit of a hybrid delay and force majeure clause. It's much broader than the first example we looked at. You'll see that the triggering event, first of all, there's some listed items which I haven't included on the slide, which is things like strikes, fire, abnormally adverse weather. And then there's a catch-all here, any cause beyond the contractor's control, other than one resulting from the contractor's own default or breach. And so this is a very broadly stated force majeure clause, and this kind is, of course, going to be interpreted radically different than the first example that we saw. But note that this force majeure clause gives an extension of time. It specifically provides that the contractor shall not be entitled to payment for costs incurred by the owner. Next slide, please. CCD-C2 is interesting because it has a separate provision regarding delay due to a stop work order issued by a public authority. And so this provision is a separate provision in CCD-C2. says if the contractor is delayed in the performance of the work by a stop work order issued by a court or other public authority, the contract time shall be extended, and notice in this case, the contractor shall be reimbursed by the owner for reasonable costs incurred. So in the one case, the contractor bears the costs of absorbing their losses, but in this specific circumstance where the delay is caused by a stop work order, then the owner bears the risk of paying for costs. It's clear that this provision could be triggered by a government order to shut down a construction site in relation to COVID-19. But it's a live issue for debate whether this clause would be triggered by a government order of general application, such as we've seen in other provinces where it's not addressed to a specific work site, but it's a industry-wide government order. So that'll be one of those pieces that will be open for some interpretation by the courts in the coming months. So this clause has significant implications whether or not it applies, because it dictates who is going to bear the costs resulting from standby or standing down or suspending work under the contract. One thing that exists in many of the force majeure clauses is a drop dead date, meaning if the force majeure event continues for a certain number of weeks or months, then the contractor usually is the one who is given the election to terminate the contract, so that the force majeure doesn't result in an indefinite suspension of the project, but it can be forced to bring it to an end. A key point to take from these couple of examples is that force majeure is contractual. There's no general advice that we can give that certain events will trigger force majeure and others won't. It depends very much on the specific contract terms and the circumstances of the project. Next slide, please. Now, hand in hand with the concept of force majeure is the common law concept of frustration. Frustration is, well, the doctrine of frustration may apply where the force majeure provisions in the construction contract are not met, or where a force majeure clause does not exist. So this is sort of the second place you look to see if circumstances impacting a project have some recourse at law. The quote in the slide there is sort of a classic definition of frustration, a situation for which the parties have made no provision in the contract and which renders the performance of the contract radically different from that which the parties agreed to. In essence, that's interpreted to mean that the events render the performance of the contract impossible. The cases are pretty clear that the concept of frustration is not triggered if the circumstances simply make the project more costly or more onerous to perform. They truly have to render the performance of the contract impossible to trigger the doctrine of frustration. And so unless you have a mass outbreak at the work site or the authorities shut the work site down, it would likely be difficult to prove frustration. Frustration is a relatively narrow concept. It's not to say that we can't see any construction contracts terminated for frustration as a result of the pandemic, but it is unlikely and it'll need to be assessed on a case-by-case basis. One thing to note is that the outcome of frustration is different than the outcome of force majeure clause. The outcome of a judicial finding that a contract's been frustrated is that it terminates the contract. And there is both case law and legislation that dictates what happens with costs in that circumstance. But in the case of a force majeure clause, the outcome of the clause being triggered is as set out in the clause, as set out in the contract itself. Next slide, please. So many of the calls we are getting are about risk assessment and prevention at this stage. We're not responding to many claims at this stage. We're dealing with anticipated claims. We're dealing with prevention of claims and understanding the contract scenario. Some of the advice we're giving in this scenario for our clients is very customized. Other advice is quite standard. Some of the standard advice is preventive steps that can be taken regardless of the situation is to respect the contract notice requirements, regardless of the unusual times. Good standard contract administration practices are key. Any contract administration checklist you might have doesn't need to be revised. It just needs to be respected, maybe without any major overhaul, but just don't let it slip. And there are extra contractual considerations that are key in this circumstance, meaning communications above and beyond the strict notice requirements of the contract are probably more important than ever. Understanding the risks and pressures of the owners, the contractors, the suppliers in the construction project. The situation may not trigger force majeure or frustration, but it might still render contract performance financially impossible or punitive on some of the parties involved. And frankly, at the extreme, some businesses may not have the staying power to survive the pandemic. And so it's time to communicate and understand those risks. Next slide, please. Another word about delay provisions. As I said, force majeure and frustration are narrow concepts. Quite often it's going to be the delay provisions of the contract that govern the impacts associated with the pandemic. Most construction contracts expressly set out the relief for delay-related impacts, such as an extension of time or possible recovery of costs, of course. In many cases, delays caused by external factors, such as COVID-19, will be excusable but not compensable to the contractor. Excusable meaning an extension of time is available relative to the contract schedule, but not compensable meaning there's no recovery of costs. The contractor is going to bear their own costs associated with such a delay. On the other hand, it's typical that delays caused by an owner will be both excusable and compensable to a contractor. Keep in mind, though, that is a very rough general rule. Delay provisions vary greatly throughout the industry, and it may vary from one contract and one situation to the next. Standard that delay provisions will require a contractor to mitigate their losses, and even if it's not expressly stated in the contract, it's an onus on the contractor to take steps based on common law to try and mitigate and keep costs down to all parties. Where you're party to multiple agreements related to the work, it's important to assess each one of those agreements, because it is unfortunately very often the situation that those agreements are not perfectly aligned or consistent as to where the risk is allocated. And it's important to understand the context of the allocation of risks up and down the chain of contracts. What costs are recoverable may vary from contract to contract and situation to situation, but certainly one of the general pieces of advice that we give to clients in this scenario is when you're incurring the costs, which are unanticipated due to the pandemic, is to track those costs, set up new cost codes, because there is likely to be some accounting required down the road. Next slide, please. From a trade contractor's perspective, the key concern, of course, is cash flows. As mentioned, it's maybe trite, but it's essential to be diligent about your contract administration, starting with invoicing and right on through. The notice provisions in the contract need to be strictly followed. Frankly, even if there are no notice provisions, it is prudent to provide written notice to the other parties to the contract if there are cost impacts that are being sustained or schedule impacts that are being sustained and likely to impact the project. We've seen a sort of a fairly wide concept in the industry of a pre-force majeure notice, which isn't really a thing, but it is a prudent step that a lot of contractors are choosing to take. It's to say, we're being impacted, and we want you to know about it. This is what we foresee coming. Some of those pre-force majeure notices that we've seen are very generic, and frankly, they're not that helpful if they're generic. But if they're specific to the circumstances of the contractor and the specific circumstances as it affects the project, then those are very prudent communications to make. And so it's critical to assess the risk and then assess your security for payment, whether it's the Builders Lien Act or Public Works Act, or perhaps any available bonding on the project if there is anticipated risks with payment. Next slide, please. So coming back, I mentioned this concept of extra contractual considerations. I guess I want to highlight that amid all this talk of claims and liens and such, of course, one of the primary tools at your disposal is to working together to devise solutions to common problems, and that should probably be a priority. Some of these challenges that we're encountering call for legal solutions, but frankly, more often the legal consequences, the contractual consequences, are more of a backstop for amicable, business-oriented solutions. Next slide, please. And so one of the key pieces, I've already touched on it, that we've had to advise clients about is whether to voluntarily continue work or shut down a project. And we've had some clients who have elected to voluntarily shut down projects and go through a number of considerations to arrive at that decision, assessing the pros and cons and legal consequences up and down. And in many cases, this will be an ongoing assessment because a project that might be viable now might run into new challenges a week or a month from now. Even if a project is not required to shut down by any government action, it's necessary to consider the occupational health and safety implications. That is, whether there are going to be OH&S reasons that the project needs to be shut down. Employers have a positive obligation under the OH&S Act of Alberta to provide employees with a safe work environment. This ties back to the definition of essential services that Richard mentioned at the outset. Construction sites are considered essential services, but there's a condition tied to that, and they have to be able to safely abide by the public health guidelines. And so that might be an assessment that is ongoing, day to day or week to week. Next slide, please. And so the site or the project remaining open, continuing construction has mitigation costs and potential liability associated with it. Employers have to take the appropriate precautions to protect the workers in the site from pandemic-related risks, and Graham is going to touch a little bit more on those in a few minutes. But an assessment has to be made if the project can continue safely, and in most cases so far that we've seen, they can and they will. But there's also a balance on the financial and the legal side. Compliance with the requirements of the health authorities may cause financial strain, and it may even lead to dispute or allegations of breach of contract in itself. The decision to shut the project down on the other side also has obvious, very significant financial impacts. And if it's a voluntary shutdown, as mentioned, it may attract liability for breach of contract. So the contractual consequences of voluntary site shutdown has to be one of the key considerations. But again, it's not the only consideration. We're also looking at issues like health and safety, the employment, the financial, and sometimes even the reputational impacts of shutting in a project or not. With that, I turn it over to you, Graham.
Thanks, Corbin, and good afternoon, everyone. Graham Henderson here. I'm going to cover 3 topics. First, I'm going to briefly talk about business interruption insurance, which is the slide we have up here. Second, I'm going to talk about dispute management during the COVID-19 outbreak. And third, I'm going to talk about the practical steps to take during the outbreak, including precautions to take and responding to a positive COVID case. So firstly, business interruption insurance. The key question you're probably looking to have answered here is whether your company's insurance provides coverage for losses caused by the COVID-19 outbreak. Unfortunately, that's not something we can answer without looking at your specific policy. Business interruption coverage only applies if the loss is caused by an insured peril. This is something that needs to be determined on a case-by-case basis by reviewing the specific policy language to determine if there is coverage for pandemics or epidemics. Unfortunately, pandemics or epidemics are not typically a peril covered by insurance carried by construction companies. There is specialty coverage specifically for disruption of business due to a pandemic, but the number of companies that have that type of coverage is limited, given that the coverage has always been expensive and even itself is limited in scope. Now, importantly, even if pandemics are a peril covered by your policy, it's also necessary to determine if there are any other policy restrictions that may interfere with your coverage. For example, if the business interruption insurance is arising from a commercial property policy, then it will likely only provide coverage when physical loss or damage has been caused to the premises. And perhaps there may be some cases where a COVID outbreak leads to a physical loss or damage, but many cases that won't come into play. In any event, it's important that you take immediate steps to protect your company in the event that it does have coverage. The things you can do at this time include, firstly, reviewing your policy with your insurance broker and legal counsel to confirm whether you have coverage or not. Secondly, properly keeping an accounting of your losses and abnormal expenses by tracking them separately. And third, keeping and organizing all supporting records for any potential insurance claim. Now, unfortunately, one thing you can't do is go out and obtain insurance to cover this pandemic now. It's too late to do that now. Next slide, please. The next topic I will discuss is the issue of dispute management during the COVID pandemic, with a focus on the court closures and filing changes. The Court of Queen's Bench of Alberta and the Provincial Court of Alberta are mostly closed. In the Court of Queen's Bench, In the Court of Queen's Bench, all litigation matters scheduled for hearing up until May 1st, 2020 have been adjourned indefinitely. All filing deadlines under the Alberta Rules of Court are suspended until May 1st, except deadlines for commencement of proceedings. Access to email and fax filing has been expanded. This is a positive thing. It increases access to filing without having to travel to court, and it allows people to maintain social distancing. However, it's still better to make urgent filings in person because there could be some delays in the email and fax filing. The Court of Queen's Bench will only hear emergency and urgent matters. There is a specified list of emergency and urgent matters, which are unfortunately unlikely to apply to most construction-related cases. The examples of cases that are emergency and urgent are, for example, orders specifically related to pandemic and quarantine, civil restraining orders, and urgent injunctions. That being said, the court does have the discretion to hear urgent matters that are not specifically listed. Also, the court is accepting desk applications, just as they always did prior to the outbreak. Accordingly, desk applications are not limited to emergency matters. However, as per usual, only certain applications are suitable for desk applications. They're pretty much limited to consent orders, so where all the parties have consented to what is going to happen, to other uncontested matters, or to matters not requiring notice to the other party. Next slide, thank you. In the provincial court, all litigation matters scheduled up until May 22nd, 2020 have been adjourned indefinitely. So that's another 21 days beyond the Queen's Bench adjournment. The court will hear urgent litigation matters, which are decided on a case-by-case basis. And the court also does have a specified list of urgent matters, but that doesn't include any litigation matters. The court has also imposed filing restrictions. You can only file urgent documents in the normal course by going to the regular filing counter. Otherwise, for non-urgent filings, you need to drop the filings in a drop box at the entrances to the Calgary and Edmonton courthouses. With respect to the courthouse itself, the general public has restricted access. Only specific people are permitted entry, such as counsel and parties to a matter that is actually being heard, or people who are filing documents. Just to note, we expect that the court's limited operations will last beyond the May 1st date set by the Queen's Bench, and even beyond the May 22nd date set by the provincial court. In fact, the Alberta Minister of Justice and Solicitor General has issued an order to suspend certain limitation periods and deadlines during the period of March 17, 2020 to June 1st, 2020. I'm going to discuss that order in further detail later in this presentation, but for our purposes now, this order hints that the pandemic restrictions are going to continue until at least June 1st. Now, some counsel are taking a pens down approach to litigation matters and using the state of emergency as an excuse to avoid moving court actions forward. The suspension of limitation periods and court deadlines, along with the closing of the courts to non-emergency matters, does make it difficult for parties to make progress in litigation if one party's delaying. However, counsel and parties should be cautious and keep in mind that once this pandemic's in the past, conduct during this state of emergency may become relevant in future applications. For example, if requests were unreasonably ignored or rejected. So in this regard, you're going to want to be perhaps even extra courteous and accommodating in these times so that things don't come and backfire at a later date. Now, with respect to the ability to still move matters forward in spite of court closures and social distancing, our office is set up to do questionings and mediations by video conference, and we're now beginning to see those activities being transitioned to video conference instead of being canceled outright. Also, there are now virtual arbitration services being offered through many companies. For example, to do a gratuitous plug, Peter Major and Jim Lebo of our firm offer commercial arbitrations by way of video conferencing. In addition, the courts and the Land Titles Office are now permitting remote commissioning of affidavits over video conference. However, just to note, there are very specific procedures that must be followed and special language that must be added to the affidavits in order for the affidavits to be effective. In any event, it's important for you to know that there are virtual opportunities that may be available through any number of providers across the country, which may allow some matters to move forward in spite of social distancing and court closures. Next, thank you. Land Titles currently continues to operate as usual, except there are some procedural changes. For one thing, they're no longer open for in-person counter services. Secondly, there are specific rules for delivering and picking up documents. For example, there's now a drop box for drop-offs. Accordingly, liens and other land titles documents, such as lien discharges, can still be filed. But oftentimes, land titles registrations also require a court order, and that's where things may get complicated. So for example, when paying money into court as security for a lien, a court order is required. You may still be able to do this with a consent order, which can be submitted by a desk application, as I talked about earlier. However, if the other parties refuse to consent, then you may not be able to actually bring an application. This isn't something we've seen come up yet, but it will be interesting to see the scenario if a court would hear a lien matter as urgent, where a lien claimant refuses to cooperate in discharging a lien by consent. In addition to using consent order, which could end up being slower right now than usual due to the desk application, we recommend that you speak with counsel to suggest placing money in trust to stand as security for the lien. So this works in the same way as an order, except instead of the lien being discharged and the money sitting with the court, the lien is discharged and the money sits in trust in a lawyer's office. Next, thank you. Now, in addition to measures taken by the courts themselves and by land titles, the Alberta Minister of Justice and Solicitor General has issued an order to suspend certain limitation periods and deadlines from March 17 to June 1st, 2020. I mentioned this briefly a couple slides ago. Now, this order suspends all limitation periods and specific enactments that are listed in the order. I'm not going to dive into the various potential impacts of this order. However, I do want to address the impact on builders' liens. The specific enactments listed in the order do not include the Builders' Lien Act, which is the act that outlines the rules for builders' liens. However, in addition to suspending limitation periods in the listed enactments, the order also states that it suspends from March 17th to June 1st any period of time within which any step must be taken in a proceeding or intended proceeding. And I have that quoted for you there on the slide. And as you can see, it's a fairly broad provision there. So the intent and scope of this additional provision is somewhat unclear. It appears to be a catch-all provision that sorry, my microphone muted itself there. This appears to be a catch-all provision that is not limited to the listed enactments. If so, this provision arguably applies to timelines set out in the Builders' Lien Act, even though the Builders' Lien Act is not specifically listed in the order. So how do we deal with this? Our advice is that since it is uncertain whether the order is intended to apply to the deadlines in the Builders' Lien Act, and particularly since the Builders' Lien Act is not even one of the specifically listed enactments, we recommend lien claimants continue to comply with all the requirements in the Builders' Lien Act. For example, the deadline for lien registration, the deadline for a certificate of lis pendens, and the deadline for filing an affidavit to respond to a notice to prove lien. The next topic I'm going to discuss is some practical steps to take in an outbreak, including precautions to take, including responding to a positive COVID case, and briefly some considerations for when work resumes. So firstly, precautions. There have been some calls in Alberta and around the world to shut down construction sites. But as long as construction sites remain open in Alberta, it is important to take precautions to ensure that the sites are being operated in as safe a manner as possible. Some options for doing so are listed in our slides here. For example, limit crew sizes to 15, which is the limit for group gatherings in Alberta, if possible. You want to ensure physical separation between workers. This means spreading out work locations and limiting the number of people in certain areas. This could also mean staggering shifts and break times. Next slide, please. You also want to reduce contact between people and the flow of people by allowing workers to work remotely and reducing the number of shift changes for people on site. It's also important to screen employees and tradespeople. Ask about whether they have any symptoms. Ask if they've been traveling. And taking temperatures may also be an option. You'll also want to promote good hygiene. This can be done by increasing efforts to disinfect, increasing hygiene messaging to employees and trades, having cleaning and possibly PPE items available for employees and trades. Also, employees should be provided with information to assist them with accessing benefits if necessary. Now, the Canadian Construction Association has issued standardized COVID-19 protocols for all Canadian construction sites. And we strongly recommend that you review these protocols and adhere to them. The protocols are available on their website, and we've provided a link to that website here. The types of practices mentioned in those protocols and in our slides here are not mandatory in order to comply with the law. However, just like any standards, there's going to be some protection from civil liability if you're meeting or exceeding these standards. Now, if one of your employees or someone else on the worksite on a worksite under your control does test positive for COVID-19, there's no checklist of steps that will perfectly fit every situation. However, we do have a number of tips for responding to a positive test result. First tip is that you want to coordinate COVID-19 issues through a designated contact person. Ahead of time, you'll want to designate this person and make sure you communicate with employees and tradespeople to advise them of who the contact person is. Next, you want to confirm with the person who apparently tested positive to confirm that they have. If you're speaking directly with the person, confirm whether Alberta Health Services or their health provider has advised them that they tested positive. You need to require the person to self-isolate immediately. The person shouldn't return to the worksite until they have recovered from COVID-19. I note that staying home for 14 days may not necessarily be enough time, so you should encourage the person to work with Alberta Health Services and their healthcare provider to determine whether it is safe to come back to work. You want to offer support to the person, let them know that their health and the health of everyone in the worksite is your top priority. Ask if the person has the resources they need and offer any resources that are available through the workplace. You'll need to complete a hazard assessment to determine the risk to your workplace and other people. Some parts of that assessment, for example, could include identifying the date on which the person tested positive or first developed symptoms, identifying when the person was on the worksite in the 14 days prior to the positive test. Those areas will need to be sanitized immediately by a qualified professional. You'll also want to identify anyone who had close contact with the person. Next slide. Thanks. After close contacts have been identified, you should contact those close contacts and advise that it is believed that they worked in close contact with someone who tested positive. We recommend that those close contacts also self-isolate for 14 days from the date of exposure. You may also want to advise the other people on the worksite who did not have close contact. However, you should take steps to ensure that you do not disclose the identity of any individual who tests positive for the virus. If you do feel that disclosure of the identity is necessary, then we recommend obtaining legal advice before identifying the individual. Another tip is you need to consider whether a temporary closure of all or part of the worksite might be required in order to protect employees, ensure self-isolation, and complete a thorough sterilization of the appropriate areas. You can expect to be contacted by Alberta Health Services, and you should coordinate your response with them and follow the directions given. Overall, the broad key for dealing with a positive test result is to make sure that you take all reasonable steps to protect the worksite and ensure that people have sufficient information to allow them to help protect themselves. And now briefly here, I'll just touch on, once the COVID-19 situation is under control, you should expect or at least prepare for projects to resume at their normal pace. That means that, for example, if a site is shut down, you should consider what will be required when the project resumes. For example, you should prepare ahead of time by considering the steps that will be required for remobilization. In reality, some contracts or suppliers may no longer be available for the project, so you'll need to have contingencies in place for replacements. And what about the added costs for the COVID-19 complications? In that respect, you will need to review the terms of your contracts and the specific articles of the contracts that relate to additional costs. And just to wrap up here, I'll note that we are in a new normal. We're going to remain here for an undetermined amount of time. And during that time, the laws, rights, and obligations are going to continue to be in flux. So it's important for you to take steps to protect yourself, your company, and your work sites. It's important to be flexible, Keep your ear to the ground and remain alert and informed about changes in the law and the pandemic generally. Offer support to employees and subtrades, and communicate effectively with employees, subtrades, and others who you encounter on work sites and elsewhere. So thanks for tuning in. We can answer some questions now if any have come in. I note that the McLennan Ross website has resources for you, not only on what we discussed today, but also on other issues such as labor and employment.
Great, thank you guys. Yeah, so if you do have any questions, you can put them in the Q&A box there, or raise your hand and then I can open up your microphone if you wanted to ask a question that way. Give everybody a few seconds here. If you don't have any questions now right away, definitely reach out to the chamber or these emails here for Richard, Graham, or Corbin, and they can help you out that way if you'd like. Not seeing any questions. We have one question here from Deb, and I believe Deb is with a roofing company. So the question here is, can a company be liable by the owner if they have a worker that tests positive?
I guess I can try and tackle that. It's a pretty broad question, I suppose. Frankly, the simple fact that let's say a trade contractor working on a site has an employee that tests positive, that fact alone is certainly not going to attract liability. But it could be a relevant factor if there's some contractual breach by that trade contractor, if they have perhaps been negligent in allowing exposure by not following the requirements of the health authorities with respect to exposures on the work site. I suppose hypothetically we could see an allegation that is a negligent act by that trade, and it could result in a claim not necessarily based on an allegation of breach of contract, but it might also be an allegation of negligence. So, the simple answer to the question, I think, no. The mere fact that a trade or whatever contractor has a worker test positive is not going to be exposure to liability in itself. It's more likely that if there's some circumstances around it that constitute a breach of contract or negligence, that could attract liability.
Perfect, thank you. Deb, is there a follow-up question or anything from there? Okay, and we've got some thank you notes here in the chat saying people thank you. It was a very thorough presentation and thank you for your time. And we got a follow-up here from Deb. Just wondering if the homeowner in a roofing situation would have to be notified. I'm assuming notified if there is a positive test.
I would think it would be prudent. I don't know if Graham or Richard, if you guys can think of a specific requirement in that regard, but I would think it is a very prudent practice if you've got someone who is working on a residential property and that person was then shortly thereafter tested positive or exhibiting symptoms. I think that's just good, both in terms of both managing the health situation, but also managing the civil liability situation to communicate that that's the case, and presumably along with that, communicate that precautions have been and will be taken.
Perfect. Thank you, Corbin.
I think you would want to be careful still, as Graham mentioned, with not disclosing the name of your employee to the homeowner as well. Those privacy reasons.
Very good point.
All right. Deb says thank you. All right. Yes, if you have any questions over the weekend, you're thinking about everything you've heard here today, feel free to send any one of us an email. I can forward any information I have here from the Chamber's point of view, or reach out and get the answer for you that way. This webinar will be posted along with the slides on our website, in our COVID-19 section on our website, and along with all the other webinars we've done so far. So thank you. We're going to wrap up here. So thank you, Graham, Richard, and Corbin. That was definitely great information, very thorough, and we appreciate you taking the time out of your day to share this information with us. And just before we do fully wrap up, I would like to thank all of our members for your support and for trusting us as your Chamber of Commerce. We are working diligently to provide you the information you need to get you the answers that you're looking for. We always, at the end of anything, thank our platinum sponsor, Thompson Construction Group. Their support is huge for us, and we know, along with everybody else, they are going through some tough times right now, and we do still appreciate what they're doing for us. This is the end of the webinar, and I'd like to encourage everybody to stay tuned for future webinars we've got in the works here. We just haven't released any dates or times, but we will be emailing everybody with that information. And so keep an eye out, and have a great weekend, everybody.
Thanks, everyone.
Perfect. Thank you, guys. Have a good weekend.
Thank you. You too.
Yeah.
Thank you, Kendra.
Welcome.
Thanks a lot. Bye.
You're welcome. Bye.